To hear the next case, in re Marriage of Bell. This is case 24-14-24, in re Marriage of Bell. We have Sasha Finke for Mr. Bell, and we have Jacob Koller for Stacy Bell. Ms. Finke, whenever you're ready.
Counsel? Because I'm positive I wouldn't be able to even recite the facts of this case in 10 minutes, I'm going to skip a recitation unless there's a particular factual issue that anybody wants me to address. Okay. So the first, I think, primary issue that Bradley feels is reversible error or needs to be corrected is the district court's interpretation of the Finley case. And I might be, is it Benelli? Essentially, what the district court determined was that under Finley, how a property appreciates is irrelevant, and has interpreted Finley and applied it in this case as if the length of marriage is irrelevant.
Counsel, can I back you up to a more basic proposition? Do you agree that appreciation, even on premarital assets, but the appreciation on those assets is subject to division? Yes. Okay, thank you.
And I acknowledge that. The concern I have with the district court's decision is how it interpreted Finley in saying that the nature of the appreciation cannot be considered, essentially, which is inconsistent with how this court has ruled since Finley was decided, specifically in short-term marriages.
Do you know how the court came up with 10%? Was it just like the 10% credit? You know, instead of saying 50-50, I think the court said, I'm going to give 60-40, right, of the net, right, when he divided. I mean, why not 15? Why not 20? Why not 5? I mean, was there any kind of reason that you could gather from case law or otherwise how that 10% number was derived?
No, Your Honor. And I think the case law specifically suggests not to do that in cases, to apply just a generic formula of percentages. And one of the issues we've raised on appeal is the fact that the district court looked at all the property as if it was just one pot of property, all has the same characteristics and the same material, despite the fact that Mr. Bell, for example, had owned several large pieces of farmland for a substantial period of time prior to his marriage, but it was treated the exact same as a piece of property purchased within a year of the marriage. And so there was no distinction given by the district court to the nature of the property that Mr. Bell had accumulated prior to the marriage, and just unilaterally applied 50 or 40%, or unilaterally just gave Ms. Bell 40% of that appreciation.
Just the appreciation though, right? So if you just said like a year into the marriage, right? Well, that's technically not true, because what the court did do, as I understand it, is it didn't include the base value at the time of marriage. Am I right in that understanding? All right.
To the marriage and not before the marriage. So I apologize for misspeaking. So
Not to keep bombarding with questions, but if you agree with that basic proposition that appreciation of premarital property is subject to division in a divorce, then are you still advocating that there should be no division of that appreciation here? And if you are, how do you support that position?
In supporting that position, our focus is on all the relevant factors, one being the length of marriage. It was an 8-year marriage, which is considered short-term under at least the cases decided since Fennelly, and even before that time.
To kind of piggyback off Judge Bading's question, so is the shortness, the fact that this marriage was 8, Fennelly was 15 or 16, does that just shift the percentage of that appreciation that should be, or like how's that how are district courts supposed to apply that kind of formula?
So for example, wherein Fennelly said it was not appropriate to emphasize how property appreciates when parties are married nearly 15 years. In short-term marriages, the Court of Appeals has routinely said how property appreciates is material and relevant. And so it's more so what factors should be considered or are allowed to be considered versus how that division is done. In this particular case, because first of all, and then again, more importantly, there was a huge disparity in assets brought into the marriage. Mr. Bell came into the marriage with several $1 million worth of assets, and Mrs. Bell's net assets were less than $75,000. Yet she walked away with an award from the court for $1.4 million. And the lion's share of that was for appreciation on property that Mr. Bell had been accumulating his entire adult life. And so
Does that really matter? And what I mean by that is, regardless of who came in with what, one thing that's not disputed by either side, as I understand it, is that the values of the various assets appreciated during the course of the marriage approximately $3.5 million, from what I can gather. Total, it appreciated over $4 million, but I think once you reduce some of the debts and the encumbrances, you come out to about 3.5 or so. I mean, so that's why should we consider what they brought in when that's the corpus of what we're talking about?
well, the case law instructs us to consider that and says in short-term marriages, the disparity of assets brought to the marriage is a significant factor. And so because that is what the case law says, and that's what we're advocating. But I do want to bring up another point when we're talking about what was agreed. So appellant's argument is twofold. One is that Mrs. Bell shouldn't have been awarded 40% of the appreciation of his marital property. But secondly, more so pertains to the district court's determination of what was appreciation and not appreciation, and essentially the premarital credit. In our brief, we argued that Bradley's calculation of what he was entitled to for a premarital credit was approximately $1 million more than what the judge actually gave him. And the reason for the significant difference is twofold. When Bradley, right before the marriage, he was operating as a sole proprietorship across the board, with the exception of Catnip Bridge. And he had, prior to the marriage, ran everything that way. But he had almost $1.5 million worth of equipment that he was utilizing in his manure business through a rental agreement, as well as that he used for his farming operation. And so during the course of the marriage, he incorporates his businesses, and the way that the court treated the assets and by adopting Stacy's allocation is Bradley was given no credit anywhere for the $1.4 million worth of equipment that Bradley had on his personal balance sheet before the marriage.
Expert note that in the report?
Yes, and I actually asked their expert on cross-examination, and he said he didn't include it because it wasn't part of the assets, but he acknowledged regardless of where that is put, it needs to be considered on the marital balance sheet at some point. Sorry, good. Drive out.
Was there a value for the equipment that was held by catnip manure during the marriage?
Yes, there was a value for the equipment immediately prior to the marriage, and then there's documentation showing, for example, personal equipment that wasn't held, quote-unquote, in catnip's name, being transferred from Bradley's personal balance sheet to catnip's, and you can see the increased value of the property over the course of the years because what happened is he eventually just phased out a rental agreement between catnip manure and his personal self. The other area, and I see my time's up, the other area that the big premarital credit disagreement exists is not providing Bradley with any sort of premarital credit for the rental properties that he sold in 2022, which was significant in along the neighborhood of $350,000. So,
Time on rebuttal. Mr. Koller?
Good morning, Your Honors. May it please the court, counsel. I represent the appellee and cross-appellant, Stacy Bell. As the appellee, we ask the court to affirm the trial court's ruling. As the cross-appellant, we ask the court to award Stacy 50% of the marital appreciation of net worth and to increase the award of additional trial and expert attorney fees. This case ultimately centers on equitable division of property. Stacy's case from trial to this point is premised on Iowa statutory law and precedent. In 2007, the Iowa Supreme Court decided the Finke case, articulating the since oft-cited maxim, marriage does not come with a ledger. Finke articulated that spouses agree to accept each other for better or worse, that each person's total contributions cannot be reduced to a dollar amount, that many contributions are incapable of calculation, that financial contributions are not to be emphasized over intangible contributions.
Focuses on that point a lot, but then you go on to sort of emphasize how involved Stacy was in the different businesses and kind of revamping their business processes. So that seemed a little inconsistent to me because there was a lot of emphasis on how involved that she really was.
Respectfully, I wouldn't say that it was inconsistent, Your Honor. I would say that we approached this case as we believed was appropriate, and that is that Finke is good law. It's been good law since 2007. Bradley approached this case as if Finke doesn't exist. And so to be prepared for an argument today or to be prepared for what the district court might do, we also had to address those contributions.
So it would be your position then if Stacy hadn't become a part of the business, had just kept her job in Cedar Rapids, would 50% of that appreciation still be merited?
Absolutely. The reason we focus on her contributions is because although Bradley wants to pretend as if Finke doesn't exist, I actually think this is a case that's a poster child for extraordinary sacrifice and contributions. Stacy had 2 young children at the time that her relationship started, for whom she gave up primary care and shifted to a joint physical care arrangement, giving up invaluable time with her kids for the remainder of their respective childhoods. She maintained her residence in Cedar Rapids because the kids still needed to be around their father and still needed to go to the same school, as did Bradley in Lone Tree with his kids and to be around his extended family. But they logistically made it work because he was with her when he didn't have his kids, and she was with him when he didn't have his kids. And
To her contributions too much, I just want to back up a little bit to make sure I understand your position. So are you saying that under Finke, we do not need to consider the length of the marriage at all when we're looking at an equitable division of the appreciation of premarital assets?
I would not suggest that Finke strips the court of considering the equitable factors in Iowa Code Section 598. Those are still relevant to the analysis to determine what is equitable. One of those factors is the length of marriage. And there have been several cases that address post-Finke, both in the Iowa Supreme Court and in the Iowa Court of Appeals, as it relates of length of marriage. Our disagreement on that issue is that Bradley believes or argues that for some reason, the length of this marriage disqualifies Stacy from receiving her fair share. And again, that's inconsistent with statutory law and Finke and precedents since Finke. The Peckham case in 2022, that was a 7-year marriage where the court determined, I think Judge Tabor authored it, that it was equitable to evenly divide the appreciated value of premarital property. The manner of appreciation does not dictate a different outcome. And like in Finke and this case, both parties contributed in countless ways to the marriage. There's other precedent also addressing the length of marriage. The Terry case in 2012 applied Finke in a 5-year marriage. The Klingeman case in 2013 applied Finke to a roughly 13-year marriage. The Nelson case in 2023 applied Finke in a 7-year marriage. And the McDermott case in the Iowa Supreme Court applied Finke to a 12-year marriage, which was also cited by the court in the decree. I'd also note that the circumstances here related to the length of marriage, we disagree that this is a short-term marriage such that it was ships passing in the night or that it was one of the 3-year marriage varieties. To me, this is closer to a medium-term marriage. Stacy was 36 when she met Brad, and she was 48 when the divorce decree was entered. That's 40% of her adult life. So when you say short-term or long-term, to me, those are matters of degree. And in this case, the relationship spanned 12 years. Of course, here we are 2 years later, still disputing the outcome of that relationship. The marriage was 6 months shy of 10 years. So to me, it's more of a medium-term marriage than within some of the analysis you'll find in case law concerning short-term marriages, oftentimes below 5 years.
Oh, sorry, go ahead, Judge.
I was just going to ask about the transitional alimony, knowing that she received about $1.5 million, was, as I understood it, employed again back at the outfit in Cedar, was it Cedar Rapids or Cedar Falls? That's what happens when you're west of Interstate 35. You know, can you talk a little bit about that, knowing what the property settlement distribution was, knowing what her salary was? Do you think that transitional alimony amount was warranted, and if so, why?
Well, the district court indicated one reason was because of the time period between entry of the decree and payment of the cash property settlement, which was, I believe, 180 days. Again, here we are 18 months later, and that still hasn't been paid, nor has the transitional spousal support. So I would ask the court to additionally consider the passage of time while this is on appeal, where she hasn't received it. The evidence presented at trial showed that she had a monthly cash flow deficit of about $1,700 per month.
That transitional alimony is aimed at, that kind of deficit. I think it's so-called, the court talks about like dividing up households, and it seems like these folks' households remain divided, that no one is buying a new set of pots and pans here.
Some reference in so-called to transitioning to another primary residence, but to me it's one example of what you might transition into as opposed to an exclusive factor for purposes of transitional support. To me, it's to transition from a household in which the primary breadwinner is subsidizing and or paying significant expenses into a household in which you're solely responsible for those expenses. You've got credit card debt that you need to pay. You've got a cash flow deficiency. You haven't yet received a cash property settlement. To me, it's an award of a short-term nature just to get you off on a fresh start or a clean slate, not burdened by coming out of the divorce process and sometimes the additional expenses that are associated with it.
Counsel, in the very short time that you have left, can you tell me why Ms. Bell should not receive why Mr. Bell should not receive a premarital credit for the rental properties that he sold during the marriage and then used to fund his hog confinements?
The rental property included assets. A couple of those rental properties were purchased after Bradley and Stacy met and before their marriage. All of those properties included debt pay down during the marriage and appreciation in value during the marriage. And the reality is that for purposes of the evidence at trial, Stacy tried a lot harder, as the district court notes, to give him credit for every premarital consideration. That one, we didn't have sufficient evidence to details what those were, and all of those proceeds went back into the marital coffers and ended up in catnip pork, which includes hog confinement buildings, one purchased right before the marriage, and then I think 3 or 4 purchased during the marriage. So at some point, we were done chasing the premarital credit, and I think it's the Solon's case that stands for the proposition that once it's back in the marital coffers, and particularly if you're not able to show or to distinguish between what should be premarital and marital, it becomes part of the marital estate.
Thank you. Ms. Finke, rebuttal.
Yes. So I want to start off with a response to the topic that Mr. Koller was just referring to with respect to the marital coffers. Again, I think it's important to keep in mind that Mr. Bell had essentially 4 operating businesses before he met Stacy, and they were very successful businesses. The appellate court decisions in marriage and dissolution cases have set aside business interests to the person who brings them into the property without sharing any appreciation or difference. The one that comes to mind is the Wheeler case, and that's a 2020 case. The husband had owned a business for 12 years prior to the marriage, which included land and inventory, and on appeal, the wife alleged that she should be entitled to some portion of the value of that business, and the district court disagreed, finding that the husband had that business for 12 years and didn't find it was equitable to award her any portion of it. And on appeal, this court agreed. And so these aren't just random assets that Mr. Bell acquired. This was his livelihood, something he had been working towards since he first started working. And that transitions to a point with respect to Stacy's contributions. Essentially, the district court found that she had impacted his businesses positively. But the references in the district court's decision are to procedures or things she had done that benefited Bradley's parents' businesses. And what was concerning to us is that the district court treated Stacy's efforts working for Bradley's businesses the same, or Bradley's parents' businesses the same as her working for Bradley's business. And again, the final point I wanted to bring up is this length of marriage. Mr. Koller argued that this is more like a midterm marriage because of the age from when they met and when they were divorced. Mrs. Bell moved back to Cedar Rapids in October of 2019. And from that period forward, until the parties were divorced, or until Brad filed for divorce, she made the trip down to Conesville every other weekend, so 4 days a week. She worked full-time. She continued to do Mr. Bell's books. However, she said that it required very few hours worth of time, and she was able to accomplish it on nights and weekends. So from October of 2019 until the time the decree was entered, that's 4.5 years. So 4.5 years, she's pretty much absent from the marital relationship, whereas Bradley, in addition to building a house that he thought she was going to move into, he continued for that 2.5-year period of time to drive to Cedar Rapids to spend time with her, thinking that she was going to fulfill what their expectation was and move to Conesville.
Court issue briefly.
Yes. And it's set forth in the brief, Your Honor, but I think it's clear that transitional alimony is supposed to be limited, and the general guideline is limited to a year. Mrs. Bell received alimony from my client for approximately that period of time already. I believe the first payment and the temporary support order was ordered for November. Well, it would have been in excess because we didn't get the ruling in this case until July 1 of 2024. So she received well in excess of 1 year of transitional alimony. And then additionally, the increase in expenses that Ms. Bell utilized at trial to support her claim that it was entitled transitional alimony really had nothing to do with the transition from being married to Bradley to becoming a single person. She already had a household that was completely furnished. The increase in expenses were her household items, just again, really had nothing to do with the fact that her and Bradley were no longer going to be together. Thank you.
Thank you both for your very responsive arguments today. We appreciate that, as well as the sound briefing. Appreciate it. We will have a written decision as soon as we can, and we will consider marriage of Bell submitted, and we stand in recess until 1 o'clock.